Mr. Speaker, sir, on behalf of the Minister for National Development, let me now move the bill to be read a second time. Sir, let me first sketch out the context of this bill before outlining the key amendments. The built environment sector, especially the construction industry, has been severely impacted by COVID-19. Almost all construction work stopped during the circuit breaker period last year. Many companies, especially our SMEs, were hard hit as no work meant there was no progress payment. Even when work restarted, companies had to adapt to new requirements, such as ensuring our workers attend their rostered routine testing and adhering to safe management measures at the work sites. In response, the government has intervened very significantly to support the sector. Amongst other measures, we introduced a 1.36 billion construction support package, extended waivers and rebates of the foreign worker levy, and provided wage subsidies under the job support scheme. The most recent measure announced last week include the waivers for foreign worker levies for construction workers, work pass holders as well as S-pass holders during the SHN period of 14 to 21 days upon entry into Singapore for a period between 1st January 2021 to 30th September 2020. We have also put in place legislation through the COVID-19 Temporary Measures Act to provide temporary relief to businesses and individuals who are unable to perform their contractual obligations due to COVID-19. This ensured that no one single part of the built environment value chain has to bear a disproportionate share of the burden brought about by the pandemic. To recap, Part 2 of the Act provides temporary relief from stipulated types of legal action and also provides firms with a defense against breach of contract and damages due to COVID-19. Under Part 8, we provided a mechanism for firms to seek relief from additional rental costs that are incurred due to construction delays due to COVID-19. Under Part 8A, we legislated for a universal extension of time of 4 months or 122 days for construction contracts. Under Part 8B, we required the players in the value chain, from builders to contractors to subcontractors, to co-share additional costs for delays also due to COVID-19. And under Part 8C, developers who face construction delay can seek relief on the dates of delivery of possession. We also provided for the co-sharing of costs between developers and purchasers of the out-of-pocket expenses incurred by purchasers where developers are not able to deliver the units by the committed delivery dates due to delays caused by COVID-19. And we are working closely with the industry partners to get the sector back on its feet. I'm pleased to share that almost all our construction S-Pass and work permit holders have returned to work, although the numbers have decreased by about 15% in January 2020 compared to the year before. The last infection case for construction S-Pass and work permit holders in our dormitories was more than 30 days ago. Construction activities at the work sites have largely resumed to approximately 85% of pre-COVID levels. And the construction demand is expected to rebound to some extent in the next few years. BCA estimates that $23 to $28 billion worth of projects will be awarded this year. However, despite this steady progress, firms in the built environment sector continue to face significant pressures in the near term. Construction projects have to manage with lower productivity on-site due to safe management measures, which are needed to keep our workers and the broader community safe. Firms face shortages of manpower and labor cost increases as we need to continue to limit the inflow of migrant workers into Singapore for good public health reasons. BCA and MOH are reviewing the safety measures at work sites, taking into account the need to balance the risk of on-site transmission and other considerations, including the vaccination of our migrant worker population. We have commenced COVID-19 vaccination for migrant workers. To date, 97% of some 9,000 COVID-19 workers from 5 largest dormitories have received their first dose of vaccine. A further 30,000 migrant workers across 30 dorms are scheduled to get their first dose in the coming weeks. The take-up of the vaccination has been encouraging, and we aim to make significant progress by the end of this year in lockstep with the nation's vaccination program. Therefore, Mr. Speaker, sir, while the sector is slowly getting back on its feet, we are not out of the woods yet. It is in this context that I am introducing the COVID-19 Temporary Measures Amendment No. 2 Bill. First, the proposed amendments to the Act will allow us to extend the existing reliefs for the sector provided under Part 2 of the Act. This will have the effect of extending the period for cost sharing in construction contracts under Part 8B of the Act. Second, the proposed amendments will also allow us to better administer Part 8C of the Act. Let me step through this in turn. First, for construction and supply contracts, we intend to extend the temporary relief measures for a period of 6 months to 30th September 2021. The construction industry has long and complex value chains with multiple tiers of subcontracting. Given the cascading chain nature of construction and supply contracts across the multiple tiers, an expiry of the relief could result in a wave of contractual disputes, especially during this time when the sector is still stabilizing. If firms are embroiled in legal disputes and forced to wind up, this could lead to a domino effect where multiple firms along the value chain could wind up successively. The ripple effect could result in further construction delays or uncompleted projects. Therefore, in consultation with industry partners, we believe that it's prudent to extend this cost-sharing relief under Part 8B for another 6 months. Contractors who incur additional costs as a result of COVID-19 would also benefit from this extension. However, the cost sharing under Part 8B will still remain at 50% of the qualifying cost and will still be subject to a monthly cap of 0.2% of the contract sum per month and a total of 1.8% of the total contract sum. That's for the contracts and supply, construction and supply contracts. For options to purchase and agreements for the sale and purchases of residential, commercial, and industrial properties with developers, including those with HDB, we intend to extend the temporary relief measures under Part 2 for a further period of 3 months to 30th June 2021. This will provide more time for developers and purchasers who are unable to perform any of their contractual obligations to negotiate and reach a compromise. In particular, in view of the impact of COVID-19 on the economy, it will assist purchasers who require more time to sort out their finances and make their payments. Clause 2 of the bill will amend the sunset period under Part 2 of the Act so that reliefs under the part can subsist beyond the sunset dates of 19 April 2021. Specifically, we propose to extend the sunset period for another year until 19 April 2022. This will allow the extension of the relief periods for construction and supply contracts, options to purchase, and agreements for the sale and purchases of properties beyond the current sunset date of 19 April 2021. Next, this bill also introduces a number of amendments to Part 8C of the Act to facilitate the implementation and delivery of the relief when it comes into operation in a few months. We have been working very closely with the relevant agencies and industry stakeholders on the operational details. We want to ensure that the process of tapping on the relief is efficient for both the purchasers and the developers, given that this will be in fact for a longer period as compared to the other reliefs under the Act. Let me first briefly recap the Part 8C relief before dealing with the specific amendments. Part 8C is intended to assist developers who are facing construction delay due to COVID-19 and are unable to meet the committed delivery date of possession to purchasers. We have been encouraging developers who are unable to meet the date of delivery of possession to first discuss with their purchasers and come to a workable and mutually agreeable arrangement. For developers who are unable to come to an arrangement and require help, Part 8C will then allow them to extend the date of delivery of possession were up to the universal extension of time provided for construction projects, which is 4 months or 122 days. Should the developer need relief of more than 122 days, they can apply to an assessor for a determination of the length of construction delay that is caused by COVID-19. And where the developer extended the date of delivery of possession, purchasers may seek reimbursement from the developer for certain out-of-pocket expenses incurred due to the delay in delivery of the unit up to a specified cap. This allows for co-sharing of such costs between the developer and the purchaser, and if there are any disputes, parties can apply to an assessor for a determination. The assessor will consider the facts of the matter and make a fair and just determination of the cost that a purchaser is entitled to claim from the developer. Let me now just highlight the key amendments. Clause 4 amends the Act to provide for the different manners in which the purchaser may claim and obtain reimbursement of qualifying costs. For example, after the amount has been determined, the developer can directly reimburse the purchaser, or the purchaser can offset the amount of reimbursement against any installment or other payment payable by the purchaser to the developer under the affected agreement. This will provide more options for purchasers and developers to settle between themselves the reimbursement that is due, based on what works best for them. Clause 5 introduces a new provision to empower the Registrar of Assessors to, on such terms as the Registrar of Assessors thinks just, extend the period within which a person is required under Part 8C to do anything. There may be instances where parties have genuine exceptional circumstances for requiring more time to carry out an action in relation to the relief. And this provision gives the registrar the flexibility to extend the time for these parties if the extension is justified. Clause 6 amends the Act to provide that a minister is to appoint one or more authorized nominating bodies for the purpose of providing assessors to hear and determine applications. As Part 8C will be operational for a few years until the projects of all qualifying contracts are completed, we can expect personnel changes amongst the assessors. Allowing the authorized nominating bodies to appoint assessors who satisfy the requirements prescribed will facilitate a more efficient management of personnel turnover. Clauses 8 and 9 deal with the miscellaneous matters relating to proceedings before an assessor, including subsequent determinations and the confidentiality of information and documents and the making of regulations under this part. Sir, let me conclude. The built environment sector builds our homes and workplaces, lays our essential infrastructure like roads and utilities, and develops our recreational and green spaces like malls and parks. An impact to the built environment sector goes beyond the stakeholders in the value chain and will affect other industries and Singaporeans in one way or another. While the sector has been severely impacted with the onset of COVID-19, it has shown grit and resilience to get back on its feet. The government is committed to partner the industry to ensure that the ecosystem continues to function, construction work continues to progress smoothly, and we do not lose important industrial capabilities even as we transform the sector. This bill is an important part of this effort to ensure the sector stays on its feet and emerge stronger. With that, Mr. Speaker, sir, I beg to move.